Hello entrepreneurs, I am Avocat Olivia Marcu-Iordanescu, and today I want to talk to you about European trademark protection. I'm an attorney at law. I partner with high-performing multipreneurs to streamline their legal processes so they can get 8+ figure funding. And this video is about European trademark protection. A European Union trademark grants you exclusive rights in all current and future member states of the European Union through a single registration. One simple registration. It is valid for 10 years and can be renewed indefinitely for subsequent periods of 10 years. Try to position yourself in the future and think whether your trademark will still be a correct representation of your brand after 10 years or more. Be aware that once you have filed your trademark application, you cannot make alterations to it. You cannot change it. The purpose of your trademark is to distinguish your goods and services from those of your competitors in the market, therefore creating a monopoly, you can say. Your trademark must be put to use, and if you do not use it, then third parties can challenge your trademark for non-use. The law establishes that a European trademark must be put to genuine use within the European Union in the 5 years following its registration. Your trademark could also be cancelled if, because of the use you make of it, it becomes the common name for goods or services, or if it becomes misleading as to the nature, the quality, or geographical origin of the goods and services for which you have registered. An EU trademark can consist of any signs, in particular words, including personal names, or designs, letters, numerals, colors, the shape of goods, or the packaging of goods or sounds. What type of trademark can you protect? Depending on what you would like to protect, a word, a figure, a color, an image, you have different trademark options. The signs that make up a trademark must be capable of distinguishing the goods and services of your company from other companies, other players in the market. To be eligible for registration, your trademark must be distinctive and must not describe what you are selling. So if, for instance, you want to register a trademark for shoes, your trademark cannot contain the word shoes. Your trademark should be distinctive. What does that mean? Well, consumers, the average consumer, should be able to recognize your sign for what it is, for example, as an indication of origin. It should distinguish you from other companies in the marketplace so that you can protect and build your brand identity and value. Your trademark should not describe what you sell. It may sound self-explanatory, right? So it should not monopolize a sign that merely describes the goods and services that you offer, the shoe for shoes. Such signs should remain available for everybody, for you and for the other players in the market. What kinds of trademarks can you register? You can register individual trademarks, certification marks, and collective marks. An individual mark distinguishes the goods and services for your company from those of others. However, this does not mean that an individual trademark has to be owned by a single person. Individual trademarks can also be owned by one or more natural or legal persons. This means that they have multiple applicants. The collective marks distinguish the goods and services of a group of companies or members of an association from their competitors. For instance, a collective production association. They can be used to build consumer confidence in the products and services offered under the collective mark. Very often they are used to identify products which share certain specific characteristics. Associations of manufacturers, producers, like I said, suppliers of services or traders, as well as legal persons governed by public law may apply for collective marks. Certification marks were introduced in the European system in 2017, and they are a new type of trademark at EU level. Although they have already existed for many years in the national systems. They are used to indicate that goods or services comply with the certification requirements of a certifying institution or organization, and they are a sign of supervised quality. Any natural or legal person, institutions, authorities, bodies of public law may apply for EU certification marks, provided that such a person does not carry on a business involving the supply of goods or services of the kind certified. If someone else has already registered your mark, you will not be able to register your trademark. So in order to make sure that that doesn't happen, you need to conduct a documentary search into the databases that are available at EU level. It doesn't cost anything when you apply to register a trademark with us, and we provide you with a fair perspective on the chances of registration. To do that, please book a free legal strategy session with me at Marcu-Iordanescu.com, and I will support you in establishing the already existing trademark rights and the chances for you to register your own trademark. And if you haven't done so already, please subscribe now to this channel by clicking on the subscribe button for more legal hacks to your leadership.